Hello, ladies and gentlemen. My name is Grant Smith Ellis, and what is officially day 17 in the John O'Keefe and Karen Read trial has concluded. It was a whirlwind series of events, ladies and gentlemen, but it concluded with a bombshell that no one saw coming in a motion hearing called by a frantic Read defense who seems like they've been devastated and on the ropes for over a week now. Bob Alessi, while arguing a minor point about a time sync correction between John O'Keefe's phone and Karen Read's Lexus data, opened the door for Hank Brennan to confirm the state has data, new data from Karen's black box EDR data that was not available in the first trial, showing a collision detection event at the very moment, ladies and gentlemen, when John O'Keefe's phone never moved again after 12:32 a.m. roughly on January 29, 2022. Ladies and gentlemen, it came out of nowhere. It was explosive, and it happened just minutes after the medical examiner in the John O'Keefe and Karen Read retrial let the world know that John's injuries, while unlikely caused by a frontal impact from a car, the front of a car, which we know didn't happen because Karen's back right taillight was broken, could have been caused by a side swipe impact, ladies and gentlemen. Oh my word, jurors haven't seen this new Lexus black box data, neither has the world, but we got our first hint today. Jurors, however, for their part, absolutely did see the testimony about John O'Keefe's injuries potentially being the result of a side swipe impact. So let us start, ladies and gentlemen. My name is Grant Smith Ellis, as I mentioned. Let us start our Day 17 recap with the moment that literally blew half of the Karen Read and John O'Keefe trial world off their feet. The medical examiner announcing that John O'Keefe's injuries could have been caused by a side swipe impact. Let's listen in.
Okay. How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that point.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes.
And you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch.
Correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
That is, Your Honor. There's not quite.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
That's the answer Brennan wanted, folks. He got the double whammy. And by the way, folks, you just heard the testimony there from the medical examiner. A side swipe impact could have caused John O'Keefe's injuries to his legs, ladies and gentlemen. And if you missed those injuries, they were revealed for the first time today as well. And folks, we are also going to talk about, in what was a horrifying moment, Bob Alessi showed a picture of John O'Keefe's, the inside of his stomach after John's autopsy, and it caused jurors to ask for the trial to be, at least one juror to ask for the trial to be suspended for a little bit, and they needed to take a break. Oh, ladies and gentlemen, there is the photos of John O'Keefe's leg confirmed. The injuries that the medical examiner herself said could have been caused by a side swipe from a car, ladies and gentlemen. You heard it. And then, folks, it got even worse for Karen Read's defense. because this was the culmination of the end of the day of the Karen Reed and John O'Keefe trial. We are actually going to watch the motion hearing. It came out of nowhere. Bob Alessi nearly had a nuclear meltdown about the collision impact event data that is going to be coming into evidence in the Karen Reed and John O'Keefe trial. And as a little bit of preface, Alessi is literally only arguing about how within the last week, the defense was informed that the prosecution's expert was able to sync John O'Keefe's phone, which the clock on John's phone wasn't synced up with the regular time, which happens sometimes with phones. But Karen's Lexus was on the right time. And so after syncing the time of the phone events to the car, the collision impact event was right as John O'Keefe's phone stopped moving and was found to have never left the lawn where John was struck allegedly around 12:32 a.m. and not found until after 6 a.m. on that blizzard on January 29, 2022, where John succumbed, according to testimony from the medical examiner, from hypothermia and a traumatic brain injury alone on that lawn. Ladies and gentlemen, we heard the motion hearing, and the reason why the collision impact event is such big data is it wasn't available in the first trial. And you are going to hear, ladies and gentlemen, we are going to listen to the motion hearing. This was the culmination of the day. Jurors didn't hear it, but the public did. You're going to hear Bob Alessi start talking about this dispute over the timeline, but then you're going to hear Hank Brennan, ladies and gentlemen, come in and confirm what the world has been waiting to hear, that there's new data from Karen Reed's Lexus that wasn't available in the first trial that shows a collision impact event. Those words, big words, ladies and gentlemen, said by Hank Brennan himself. And you're here for the recap with your friend. My name is Grant, Howard Cosell, David Attenborough, Towell Smith Ellis, and I'm thrilled to be with you all as we watch what was the culmination, the shock culmination of day 17 of testimony in the John O'Keefe and Karen Reed retrial.
I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm ARCCA. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes.
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of ARCCA, particularly the slide presentation of Dr. Welcher, a trigger called 1162-2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of ARCCA, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ARCCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCCA because two reasons. We are the defense, and ARCCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that?
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARCCA.
All right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event, of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
Case in chief. On my case in chief, because we now have this available data. As I said, this wasn't ambush. It isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance.
Bob Alessi gets this completely wrong. Hank Brennan knows it better than him. But folks, there's a point here. This was huge. Did you just hear this? The segue is Hank Brennan knows when Karen Reed's car even started at the waterfall. Time and place location. And you might say, Grant, did we get a preview of this? Did you and Murder by Maestro literally, were you all yelling about this to like an audience, a very small group of towel friends for months? Were you and Murder by Maestro just yelling from the rooftops because were you listening to court hearings during the pretrial process and you know something like this was going to come before they even did the chip off of the data in December of 2024? Yes, because we are compulsive and Murder by Maestro speaks hexadecimal and I'm a towel. Now let's listen to this, folks. If you didn't get the implications of that right there, collision impact event right before John's phone last moved, and ladies and gentlemen, they got time and place GPS data for Karen's car. It's all coming in. Bob Alessi literally was begging for a continuance of the trial. The defense, he said the exact quote, ladies and gentlemen, let me read it for you from the towel notes. "We are in an almost impossibly challenging situation," said Bob Alessi. Oh my dear goodness, what a moment. Let's watch why. Let's watch this Murder by Maestro. You know it's a victory lap for you in Little Towel, even though we don't really take victory laps in criminal trials. On this one, we worked hard, my friend. We were right, and the world shall soon knoweth that Murder by Maestro and Little Towel proclaimed it to be so. The omniscient, prescient forces that is the Little Towel and Murder by Maestro. God bless us all. I didn't even catch that the first time. Did you all hear what he just said? The best laid plans of mice and men, folks. The best laid plans of mice and men.
What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. Navigation information, phones that were plugged into the radio, travel logs, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the infotainment system, there were actually 3 boards, not one. Only one was taken out. So there is a plethora of information on these chips.
Wait a minute, I didn't even catch that the first time. Did you all hear what he just said? Hank Brennan said that it wasn't just that only one of the 3 chips was read. The reads expert used the wrong software or the wrong chip reader, which is hardware. Oh my God. Oh my God. Oh my God. Murder by Maestro. You were right to be yelling from the rooftops about this, my friend. I will tell you right now, you nailed it right on the money. Could not be any more prescient. Nailed it. Nailed it. Nailed it. Absolutely 100% nailed it. There is a lot there, folks, and we haven't even heard the disclosures about what this detail is going to contain. I have my prescient forecast based on my extrapolation of all of the evidence in this case, being one of the few people who has read every single thing on this godforsaken 700-item docket at this point. But I'm telling you, folks, I'm telling you this is huge. I'm telling you now that it's huge, because it wasn't just the chip-off was incomplete and only one of 3 chips was extracted and read. It was that the wrong software was used initially, too. Oh, my God. Oh, my God. It was definitely, I have a strong feeling Karen Reed's expert was like, oh my God, I can't believe Lally's letting me do this. Let me give myself some plausible deniability. Well, Brennan's got all 3 chips now, and the data went from 2.4 gigs to 8 gigs. Oh my word. I'm so glad we watched this. Folks, Murder by Maestro just put it together. Brennan's got 2 new chips. One of the chips is the infotainment system. One of them's the EDR. He's got collision detection event right as John's phone never moved again. Brennan's got Karen's time and place. The trip back to Fairview around 5:23 right as Karen left the voicemail. Oh my dear God. The collision detection event. Oh, it's all coming in. They got her. They got her. It's over. That's why Karen definitely had a mental breakdown on Monday. She wasn't tired. She got this information last week. She knows it's over. They got her. Folks, they got her. I'm telling you right now. You watch that last clip. You watch me beaming with that smile. It's not just me. Murder by Maestro and I were both onto this. We're right. We were the ones who heard these motion hearings before the chips even got extracted. We both knew what was coming. We could sense it. We were able to put it together. And that's why a lot of folks would be like, and I'd be like, why aren't you all seeing this? I would implore the media, like, listen to me. I know that I am right. And they would be like, I know, Grant, I know. And I'd be like, listen to me. My God. Oh, my word, we were right all along. Yeah, exactly. That can't hit a trigger event. So, but that, Murder by Maestro, we could see how he could get confused because he's dealing with this new report, which has probably new data from the infotainment system and the chip off from the EDR. Oh, my word. Ladies and gentlemen, we all see. Our eyes are open to the light. Oh, praise be, ladies and gentlemen. You were here during the recap. You saw it all put together. I figured it out live with Murder by Maestro. Had to come in to help. It was a towel assist. Oh, my word. Oh, my word. Ladies and gentlemen, that was not even the full summary of the day. Day 17, our summary continues. Now, let's look at this, ladies and gentlemen. Let's look at this. I will say it, ladies and gentlemen. I will say it. There was way more as well. We also got an expanded buffer zone from Judge Cannone. I will give you a very quick summary of that. You can find it on my Twitter as well. That really was what started the day. Apparently, I'm not only a horse racing announcer towel, I'm also a auctioneering towel, in that I can say things very quickly and do a recap really quickly. Ladies and gentlemen, let me show you it right now. Let me show you it. I will show it to you, ladies and gentlemen. This is the buffer zone order from this morning in the John O'Keefe and Karen Reed trial. The procedural history is thus. A buffer zone order entered that is larger than the first trial's buffer zone. It was appealed to the Federal District Court in Boston by way of something called a request for a temporary injunction. That was denied. The request for the temporary injunction was procedurally appealed to the Federal First Circuit Court of Appeals in Boston. The Federal First Circuit Court of Appeals, in a ruling earlier this week, said that the motion to enjoin, the denial would not be reversed, but would be vacated and remanded for further consideration by the lower federal district court. That means the status quo prevailed, and over the past few days, the buffer zone has been in effect. But then the counsel for the parties appealing the buffer zone to the First Circuit Court of Appeals filed an emergency motion for clarification and reconsideration of the court's Monday order for the remand, not the reversal of the buffer zone, denial of the injunction for the buffer zone, but the remand, the vacate and remand. The clarification said that there needed to to be more of a, from the First Circuit Court of Appeals, said that there needed to be more of a robust factual record with regards to the mens rea component of the buffer zone. This means that under Cox v. Louisiana from 1962 or 1963, when you have a statute related to picketing or anything around a courthouse and it affects more than court property, you can have that statute, but you have to tailor it, narrowly tailor it to an intent requirement related to impacting the judicial system. So now there's a new buffer zone order. It does not actually change the buffer zone. Everything about the buffer zone is exactly the same. All it does is add a mens rea requirement for enforcement, and it provides an opportunity to appeal any enforcement actions to Justice of the Norfolk Superior Court. Okay, that's it. Now what will happen from here is this is now a more robust appellate record. The Federal First Circuit Court of Appeals will send it back down to the Federal District Court, which will weigh the issue again for the request for a temporary injunction. I think the Federal District Court will deny it again. Randazza will appeal it up to the Federal First Circuit again. Then they will deny it under Cox v. Louisiana because of the mens rea component added to Judge Cannone's order. That's why she wrote it that way. It's all designed that way on purpose. Now, we have a little bit more testimony to listen to because we're doing day 17 recap. And by the way, Tao really likes to do his recaps clearly. So we already talked about how Dr. Scudorti-Bello testified, but now we need to listen to Hank Brennan's redirect of Dr. Scudorti-Bello. I think we actually already heard that component. So we'll hear the very, very end then of Dr. Scudorti-Bello's testimony before the lunch recess about John O'Keefe's injuries. But also, folks, before we do that, let's look at the moment that Bob Alessi literally caused the trial to come to a screeching halt because he started showing pictures of the inside of John O'Keefe's stomach on screens in the courthouse and definitely upset like half the jury. So let's find that exact moment. I know I have it here. I got it right here, folks. Let's watch it. You can even watch Little Tal's commentary. That's how intense it was. Oh my words, ladies and gentlemen. Grant Smith Ellis here. The Karen Reed defense via Bob Alessi has just made a major tactical error in the afternoon session of day 17 in the John O'Keefe and Karen Reed trial. Oh my word, Bob Alessi showed the jurors pictures of the insides of John O'Keefe's stomach, excised from his body after his autopsy. Immediately, within a minute, jurors asked their bailiffs for a break. Ladies and gentlemen, we're going to watch the moment. Thankfully, the stream didn't show the pictures. Ladies and gentlemen, the Bob Alessi, for no reason, this has to do with whether John O'Keefe had hypothermia as a result of Karen Reed leaving John O'Keefe on the lawn after allegedly striking John with her car, causing a traumatic brain injury. And then John's phone indicated he never left the spot on the lawn after 12:32 a.m. and 16 seconds on January 29, 2022, when Karen Reed, with a blood alcohol level of 0.14 to 0.28, which is 2 to 4 times the legal limit, backed her car up to 24.2 miles an hour, reducing to 23.7 miles an hour at the moment of impact with a 4.7 degree steering wheel correction to the right. And then left John to die on that lawn with his body temperature getting as low as 60 degrees or so the next morning. Ladies and gentlemen, Bob Alessi didn't have to do this. The jurors must have got sick. They asked their bailiffs for the first time in the trial to stop the trial. Let's watch the moment.
Your Honor, can we take a break?
Yes.
Jurors.
Yes.
That was the jurors asking for a break. It was devastating. And now we will close with the most apropos moment, the moment that folks need to keep in mind, which is the injuries that John O'Keefe suffered in the moments after he allegedly was struck by Karen Reed's car. The room went silent. Ladies and gentlemen, let us listen.
In his skull, and also your observation of Mr. O'Keefe's brain. You mentioned earlier that you use other resources, other testing. Did you ask for any type of assistance on toxicology analysis for Mr. O'Keefe?
Yes, it is routine and it is protocol to submit toxicology specimens to the lab for examination.
May I approach, Your Honor?
Yes.
Thank you, Mr. Brennan. Doctor, I'm handing you a document. Do you recognize that?
Yes, this is the report of toxicology from the State Police Crime Lab. for Mr. O'Keefe's autopsy.
Have you seen that document before?
Yes.
Is that a fair and accurate depiction of the report we saw before?
Yes.
Do you want to introduce this as the next exhibit, please?
No objection, Your Honor.
Thank you.
Exhibit 161.
Thank you. I have that in front of me. Sure. Thank you very much.
Thank you.
In your experience, Doctor, are you familiar what the toxicology report and the testing involves?
I'm sorry, what was your question?
Are you familiar in your experience with what is involved in a toxicology test?
In general terms, yes.
And if you studied Mr. O'Keefe's toxicology report, was that important or part of your analysis in your ultimate conclusions?
It was one piece of evidence that I took into consideration, yes.
In the toxicology testing, is there a search to see if there are any type of drugs or medications in Mr. O'Keefe's blood?
Yes.
Okay. And was there any?
There were no prescription medications. There were no illicit drugs in his system.
In a toxicology, is there also a testing for blood alcohol content?
Yes.
What is the difference between ethanol in heart blood and ethanol under 1102?
In vitreous humor?
Yes.
So we usually submit multiple specimens for toxicology. Some of the specimens are used for screening of classes of different drugs, and then other specimens are used to confirm, the presence and quantify a particular drug. So in this particular case, the lab tested the heart blood, which showed that it had an ethanol level of 0.21 grams per deciliter. And they also tested the vitreous, which is the fluid that sits behind the eyeball. And in that specimen, the ethanol was slightly higher at 0.28.
Thank you, Doctor. After your autopsy and observations of Mr. O'Keefe's body, inevitably did you come to a conclusion about the manner and cause of Mr. O'Keefe's death? And I'll ask you first about the cause. To a reasonable degree of medical certainty, did you reach a conclusion about the cause of Mr. O'Keefe's death?
Yes. The cause of death was determined to be blunt impact injuries of head and hypothermia.
You mentioned two different things, blunt impact and hypothermia. Was
Correct.
there a primary cause of death in your opinion?
The blunt impact injuries of head.
Hypothermia, was that sufficient to be a primary cause of death in your opinion?
In the absence of head trauma, hypothermia is a cause of death, but I'm not able to make that determination in this case because we do have the blunt impact injuries of head.
So if I understand, you are not saying to a reasonable degree of medical certainty that hypothermia was the cause of death?
Not the primary. It contributed, but the primary cause of death was blunt impact injuries of head.
Did you learn what Mr. O'Keefe's body temperature was when he was brought to the hospital?
Yes, some of the medical records stated that his body temperature was 80.1, I believe, degrees Fahrenheit.
And what is a normal body temperature?
98.6.
Regarding the blunt force injuries as the cause of death to Mr. O'Keefe, at some point when you were conducting your autopsy, or even at the end when you drew your conclusions, were you able to reach a conclusion as to the manner of Mr. O'Keefe's death to a reasonable degree of medical certainty?
No, I was not.
After you complete your findings, including the manner of death and the cause of death, even if undetermined, are you required by statute, by law, to file a report or a document?
Yes,
And what is that document?
it's the death certificate.
Did you do so in this case?
Yes.
When you file a death certificate, do you include your ultimate conclusions regarding cause and manner of death?
Yes, there is a death certificate that is issued immediately after the autopsy. The death certificate is a document that is necessary for the family in order to make funeral arrangements and proceed with their plans. So a death certificate is always issued at the end of the autopsy. If the cause and manner of death are known at that point, they are stated on the death certificate. If they are not, or if we need to do additional studies, then both the cause and the manner are listed as pending. And that death certificate is sufficient for the family to make arrangements. Later, as we get more information, as we get more results from our studies back, we issue an amended death certificate. So that amended death certificate will have a cause and a manner. The amended death certificate in this case stated that the cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
So you understand that, folks? That was the big moment of the testimony.
May I approach, Your Honor?
Yes.
This is the distinction between cause and manner of death. There was a cause of death. Ladies and gentlemen, you heard it there. Blunt impact injury and hypothermia for John O'Keefe. It was devastating. As we approach 10,000 people on the X feed, ladies and gentlemen, my name is Grant Smith Ellis. You saw it, folks. You saw it. There's only one more thing we have to watch. I'm sorry to have to do it to you, but there was a second section of the end of the day motion hearing. And yes, for the purposes of completeness, as if we were functioning under MRE or FRE 106, the rule of completeness, we must watch the second half of the motion hearing. You're going to have to get tormented. I'm so sorry.
A more layperson's term is a variance of time.
Hold on, I'm going
Your
to jump
Honor.
forward.
Has overruled government's objection and has
Actually say this, Your Honor, there's nobody that's more surprised to getting this than the
deadlines without any excuse.
What's your argument?
when we got it on May 11th.
Okay.
So this is the second part of the motion hearing. This was how the day ended. We have to watch it, folks. Here we go.
Thank you. The other issue about calling your...
Oh, so let me explain what's going to happen here. This is the part where ARCCA turned in their discovery just a few days ago for Reed's experts, and Hank Brennan found out that ARCCA's reports indicate serious flaws, and Hank Brennan's expert, who was supposed to testify soon, now has to do more testing. Let's listen.
expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government's objection and has stated that it is going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review and to prepare and to address it. The Commonwealth has the burden of proof
The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCCA witnesses. That's going to take time. You've heard from the ARCCA witnesses themselves that the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon, because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We will going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information and material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Alessi, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARCCA and the information of ARCCA, it's very important analytically to put them in their 2 proper buckets. The first bucket is the information and opinions of ARCCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCCA is doing is in response to the testing of Aperture. ARCCA did not come up with new approaches, we, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now, with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Alessi. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
All right, we're done for the day. Folks, we really were done for the day. It was wild, folks. If you missed it, here's the quick recap. Oh, my word. Oh, we have one more thing to watch. Hold on. Stay with me, little towels. We have one more thing to watch. If you missed it, Hank Brennan's got Karen's number on the vehicle data. Hank Brennan's got a collision impact event. I got it for Murder by Maestro. We got one more thing on Karen's vehicle data. Let me know, folks, whether you think, based on the medical examiner's massive testimony, that John O'Keefe's injuries could have been caused by a sideswipe impact by the car, and whether you think Hank Brennan's new data, new EDR data about a vehicle collision event lines up with Murder by Maestro's stunning reconstruction, which, I mean, remember, it's modeled, but it's a stunningly well-done reconstruction. Is this what happened to John O'Keefe, ladies and gentlemen? Is this what all the testimony on day 17 is leading up to? Let's watch the reconstruction. Ladies and gentlemen, what do you think? In some sense, it all lines up. This is Murder by Maestro on Twitter. Definitely check Murder by Maestro out. He has been on top of this vehicle data, and now we know there's a collision detection event. Murder by Maestro may have been the first person in the entire world, the first towel, the first super towel, member of Ordo Noble Linto, the Order of the Noble Towel. God bless you, Murder by Maestro. This is tough footage to watch, but I think you got it. I think you put it together. I think it's going to be very similar to what Hank Brennan's experts are going to show, and they have the vehicle data showing the collision impact detection event. Oh, ladies and gentlemen, it all lines up. The damage to John's arm, the damage to John's leg, the side swipe conclusion possibility from the ME, from the medical examiner. Oh, my word, ladies and gentlemen. Murder by Maestro is the GOAT, says Def Otter, the greatest of all towels. Oh, the towels are flooding the chat. They are all saying that Murder by Maestro's prescient prediction has nailed it. You know what we have to do, towel friends? We have to put up a towel poll. We have to put up a towel poll. Do you feel Murder by Maestro's amazing reconstruction video is accurate as to Karen hitting John? Oh, ladies and gentlemen, only Murder by Maestro could put something together like this. I put up the poll. Look at, folks, what are we going to see? We're running the poll in real time to end the recap. Will this be another prescient prediction? The poll is now running. I know some votes are going to come in nearly right away. Oh, it's yes, folks. It is yes by an overwhelming majority. Folks, the towel fandom has spoken. Oh, it's playing, folks. Don't worry. It plays over and over because I put the poll up. The towel universe has spoken. This is game over. Murder by Maestro didn't even know about the knee injury, but it all lined up because Murder by Maestro is a prescient towel. The vehicle data, the GPS location, the collision impact event from the EDR black box, the chip-offs. We know that 2 new chips were recovered from Karen Reed's Lexus. The infotainment chip, the EDR chip, both not initially extracted by Karen Reed's expert during the first trial. The bombshells keep coming. Karen Reed's defense got this information a week ago. That's when they started melting down. Bob Alessi literally freaked out in the courtroom today to the point where he had to ask for a continuation of the trial. Ladies and gentlemen, he's going to ask again tomorrow morning. Murder by Maestro is a wonderful little towel. My name is Grant Smith Ellis. These moments are hard to watch. Join us again tomorrow, youtube.com/@GrantSmithEllis. But Murder by Maestro has put it together, ladies and gentlemen. Murder by Maestro, you saw him popping up in the chat, combined with Little Towel months ago, November, December 2024. We were calling it. We knew this was coming. The collision impact event, the time and place location of Karen's car. We knew it, ladies and gentlemen. Watch tomorrow. Where will this all go next? Friday's testimony. Be with me, 7:30 a.m. Eastern. Join the Towel Friends. It's a wonderfully loving community. It's very peaceful. It's very compassionate. It is a place unlike any other. We even have people on different sides of the case who disagree with each other but are respectful. Ladies and gentlemen, and that matters. My name's Grant Smith Ellis. I'm a Little Towel. We will talk tomorrow. I'm ending this recap, and I'm going back to talk to the Towel Friends as always.